because this is where you have to speak. Yeah?
Thank you. So this was my homework given by Igor. And I was thinking what to put behind this quite complicated title. So I decided that it would be much more interesting to you because I didn't know that it would be the last speech. But the idea is not to talk about the procedures, but something more exciting. And this is how the legal mind works. So it's all about critical thinking. The main point is problem solving. But to solve the problem, we need to analyze things, be creative, open-minded, and communicate it with the relevant institutions. So shall we try to solve the problem? First, we have to analyze it. Everything has to be put in the historical context to understand it. And it will take us quite a long way back to antiquity. So in Roman law, you have a special basis for liability of the ship owners. It is receptum, not fault, receptum. I gave you the goods, you return the same goods to me. Otherwise, you are liable unless there is a shipwreck or pirates. And this concept was carried on in the medieval statutes. So this is the statutes of Dubrovnik. What it said is about seaworthiness, already in those days they have it, and receptum. But receptum is very interesting because we have scribanus navis percatoria, which is a notary of the ship. He would record everything what is loaded on board, and that should be given back at delivery. And for our students, the receipt which the notary was given developed later into the bill of lading in the 17th century. And now the same concept came into the civil and commercial codes of the 19th century. This is Napoleon, and this is Josephine. This is the Code Civil, and she is showing the new code. And the same concept of common carrier was introduced in the common law countries. But at the same time, from 17th century, we had another concept, free market and freedom of trade. And of course, with this goes the freedom of contract. It is the law, but you can decide whatever you want. You can agree what suits the parties. And then we come to the Industrial Revolution. Factories, people moving to the cities, working long hours in the factories, and shipping played a very important part. Not only that commodities were traded, but a lot of people left Europe for Australia and many South America and so on. So in those days, the freedom of contract prevailed over the strict rules. But how long did so far? Already in the States in 1990s, there was a Sherman Antitrust Act. They said, well, you can decide or agree whatever you want. But if you have a monopoly, then we cannot tolerate that. And that is Antitrust Act was introduced. But the ship owners continued to put exoneration clauses into the bill of ladings, basically saying that they are not responsible for anything. So everything is at the risk of the shipper. And then in America, they say, oh no, because there were shippers mostly, and the shipping nations, they were British, basically. So they said, no, it could not work that way. And they accepted mandatory rules for protection of the weaker part. So the ship owner and ship owners clauses which exonerate them for negligence, fault, or failure in proper loading carrying the cargo would not be accepted anymore. Then Australians said, Canada, New Zealand, oh, we shall pass the same act and we will copy Charter Act. And that means that we are having international trade, which maritime international trade, which is governed by national laws. So the people say, well, we should have an international convention, international rule, which would unify all of these rules, and we would have just one legal regime for everyone. So the Hague rules were passed. After that, many other conventions followed. And the last one is the Rotterdam Convention, or Rotterdam Rules, which has 100 articles against only 16 of the Hague rules. Obviously, the things were getting more complicated over time. So the question is, who is liable under the various regimes? So the Hague rules say that neither the carrier nor the ship shall be liable for losses caused by specified exonerations. And who is the carrier? The carrier includes owner or the charterer who enters into a contract of carriage with a shipper, and eventually, after receiving the goods into his charge, the carrier or the master or agent of the carrier shall issue a bill of lading. How it works in practice. So there are all persons or entities on part of the ship. And the master or the agent issue a bill of lading to the shipper. The question is, who is the carrier? We don't know. The carrier would be the person on whose behalf the agent or the master issue the bill of lading. If they issue a bill of lading, so there are question marks. Yeah? So they issue a bill of lading and sign it for agent for the carrier. Again, who is the mysterious carrier? We don't know who it is. So how we can find who the carrier is? BIMCO came with a form in trying to help to solve the puzzle. So what they say, when you fill in the form, please delete, here it is, what is appropriate. So if the agent is issuing the bill of lading, he would say it's the agent. Then he would tick one of the boxes, say for the owner, and insert the name of the owner and the name of the shipping agent. So we know who is the carrier. But if he ticked that for the master, then again, we don't know whom the master represents. So how we can find out? We have to look all other clauses of the bill of lading. So if there is an identity of carrier clause, it says the contract evidence in this bill of lading is between the merchant and the owner. How now we know? The owner of the ship is the carrier. Or we can look at the logo. Maersk. So it's a Maersk, so we know who the carrier is. And these are the leading cases in England which deal with that matter. Now, who else is liable? We already mentioned that Himalaya case. An elderly lady, a widow, took the cruise in the Mediterranean, and the ship docked in Trieste. So she went to a disco club in the evening, and she was coming very late on board the ship, and the very strong Bura wind, which we have here, and yesterday was blowing here, moved the ship from the shore for a couple of meters. And then the gangway drifted at the shore side and collapsed, and she fell from 5 meters on the pier, on the board. So she decided, to sue the ship owner, but there was exoneration clause saying you are taking this voyage on your own risk. So freedom of contract, and the ship owner is not liable. So she decided to sue in tort the master, Mr. Dixon, and the bosun. Why? Because they were negligent in putting the mooring arrangement of the ship. Because of that, the ship moved, and Miss Adler suffered injuries and damages. And another celebrated case is the Milan Silicon Stratton. The stewardess dropped a barrel of chemicals, and the content leaked. So, bill of lading holder sued the ship owner, but there was a limit of liability under COXA, Paris Goods by Sea Act, because the cargo was coming from the United States. So they find another solution. They sued in tort stevedores and received the full amount of damage. And now the ship owner started introducing so-called Himalaya clause called after the ship, saying that no servant or agent of the carrier shall be under any liability to the shipper. So they try to protect the servant and agents. And then we got the Hague-Visby rules, which just accepted that protection, but only for the servants and the agents, but not independent contractors. So the stevedore would not be protected under the Hague-Visby rules. Now, the Hamburg rules. This is an area of decolonization. And third world countries formed an unaligned movement, which was very strong because a lot of countries were involved. And they wanted to replace the Hague rules with a modern convention, which would be fair and would protect their interests. So what they did, they copied Guadalajara Aviation Convention. And that convention had actual carrier introduced. So how it works? If you want to fly from Sydney to Zagreb, you buy ticket with Qantas and you fly directly to Zagreb. But if there is no direct flight, then you have to fly to Zagreb with Qantas and have connecting flight to Zagreb by Croatian Airways. If an accident happens, you can sue both of them, the contracting carrier and the actual carrier, provided the accident happened on the leg of the voyage performed by the actual carrier. And this is the Hamburg rules, just accepted the concept of actual carrier. And then we are coming to the convention's Rotterdam rules. Why Rotterdam rules were drafted and eventually accepted? A simple reason. Americans, again, you know that the Hague rules were accepted because of the Harper Act. They say, there is a national legislation and we need an international instrument. So better we should create one. So it's the same situation here. In the US Senate, COXA 99 draft was there, and the international community panicked. They said the largest country, trading country in the world, would trade with the rest of the world on their own law, domestic law, instead of the international convention. And then COXA had a concept of performing carrier, which means a person that performs, undertakes to perform, or procures to be performed any of the contracted carrier's responsibilities under contract of carriage. Then CMI steps into scene, and they say, stop, we shall make an international convention. And they produced 2 drafts. And what they did, they copied that performing carrier concept Because if you want to please Americans, then you say, please do not pass your own act, but we shall create an international act which would be the same as yours. So the concept of reforming party entered into the convention, draft convention. So what does it mean? You can sue everybody. Because whoever performs, undertakes to perform or procures to perform, you can sue anyone down the chain. And that one is not party to the contract of carriage, has no copy of it, has undertakings under the convention, but has no terms and defenses under the bill, under the contract of carriage. Sorry, no, under the contract of carriage of the service contract which they have with the shipyard. So then it was CMI working group and the Croatian delegation and FIATA at the time. There are Federation of Freight Forwarders. We proposed that a performing party would mean a person that physically performs. What we did, we say, go back to the law of tort, which means only one who physically performs because of that causes damage. That one could be then sued as performing party and nobody else. Americans said, okay, that's fine, provided you added the following: fails to perform in whole or in part. And when we said, if he fails to perform in whole, it means that he undertakes it. Because what does it mean, perform in whole or in part? If the stevedore did not show up in the port of discharge, so he undertook to perform, but he didn't cause damage because he didn't work. He didn't discharge the container. So eventually it was decided that the American proposal would be put in a spare brackets, which means that is subject to further deliberations and final decision. So the very interesting thing is that a contract of carriage cannot effectively confer rights or impose duties on those who are not parties to it. That's the privity rule. And the international associations, business associations, raised their voice. And they said instruments should deal with the liability of the contracted carrier only and should not create a right of suit for cargo interest against any performing carrier party. So they want to channel liability to the contracting carrier. And these are very important international associations. They cover a lot of shipping industry. And what is now a problem with that? The critics came in and said, the practical effect would be to leave cargo interest without an effective remedy where contracting carrier was insolvent or otherwise not amenable. And secondly, preemption of bailment and tort law, that would be preemption of bailment and tort law. What does it mean? I will explain in a moment. So is insolvent or not amenable. That means that you care whether the carrier has sufficient assets to pay the claim, whether he is amenable. It means whether he has an asset which is hidden in a tax-free island somewhere in the middle of the ocean. And Professor Lunarelli of Italy said, every regime that provides for the channeling of liability also includes mandatory insurance, which does not exist in this context. There is no mandatory insurance. So the December CMI draft and UNCITRAL draft had the same definition, which was proposed by Croatian and the FIATA delegations at the CMI meeting. And then, complete surprise. The convention came out and the liable parties were the carrier, which means the contracting carrier, performing party, maritime performing party, and then was a caveat saying that inland carrier is a maritime performing party only if it performs or undertakes to perform its services exclusively within a port area. So instead of channeling liability to a contracted carrier, we get a series of potential carriers who are liable to the cargo interest. Getting quite complicated. And now, where the maritime performing party operates. So from the moment the cargo enters the port of loading to the moment the cargo leaves the port of discharge. And this is the area operational theater of the maritime performing party, which would include this one, which is an actual carrier. So it's not only constructed, but the actual carrier performs between these two ports. So what about the actions in tort? What is the idea behind? Convention drags into its regime parties not privy to the contract of carriage. They don't want to do anything with the contract of carriage. They're just doing their part of the job. This is, say, for the stevedores, discharging of the cargo. But even though they don't want to be in the regime of the convention drags them in. So the performing party gets protection and defenses against claims in tort, but gets obligation to the third parties on convention terms. So, and this is what is reflected in the Article 4. And I will explain how it works. So if we have the container here, and container has to be discharged, then there is a service contract between the ship owner on the one side and the stevedore. And if the container is damaged, the bill of lading holder could sue the contractual carrier under the bill of lading, and the performing party, because either it physically performs or undertakes to perform. And say, for example, that in the service contract, there is provision that before the stevedore would perform its job, that the ship owner should pay the outstanding debt. And the ship owner did not pay the debt. The stevedore did not appear, but still the bill of lading could sue him under the convention, regardless of the terms of the service contract. This is the problem. And the Rotterdam rules are stuck in the mud. They were passed in 2008, and so far they were not entered into force. So how to take them out of the mud? And we propose amendments. That is to pass that red line and have compulsory or mandatory insurance for the contractual liability of the cargo. Now, this is a big problem. And we try to explain that it could be very easily overcome. So this is the Columbus Act, because Professor Zunarelli said that mandatory insurance does not exist in this context. And we say, well, bring it into the context and all the problems would be solved. Is that a problem to have a mandatory insurance? No, because we have 53,000 merchant ships trading worldwide, and all of them are covered by the P&I clubs, even the charterers. So the money is there for $3 billion. This is insurance scheme of the P&I clubs. The money is there. So on the side of the ship, you have a ship owner, bareboat charterer, time charterer, voyage charterer, ship's manager. Everybody could be insured by the P&I clubs, their liability. And we have cargo insurance. So the scheme would be the bill of lading holder would sue the carrier, could arrest the ship, and have direct action against the insurer. How we shall know who is the carrier? Because the carrier will be designated in the bill of lading, and particulars of approved insurance policy would be inserted as well. It is in everyday practice. Nowadays, you cannot charter your ship out without giving proof that the ship is insured or entered with the P&I class. And even the P&I clubs are sending directly confirmation to the charterers. So when they get it, they charter the ship. Now, how direct action would work? This is what we propose, is that the bill of lading holder would sue the carrier, obtain the judgment, and in the tempo giudicati, which is time for payment of the judgment, if he does not receive money, he would sue the insurer. So that would be an enforcement action against the insurer. But otherwise, he can always arrest the ship. So this is very important point which we are trying to make to the CMI. Say, we have a European directive which asks the ship owners to have mandatory insurance. But there is no direct action. So if there is no remedy, what's the point of having mandatory insurance? Very simple. If the ship enters European ports, if there is an accident, they would arrest the ship. The P&I would give guarantee, and you have direct action upon the guarantee against the ship owner. So what the European Union did actually is make sure that every ship which enters European ports would get P&I letter of indemnity if the ship is arrested for any claim in Europe. So it's simple as that. So what we are saying now, that it is very easy to introduce mandatory insurance because we already have it. And when the European Union asked for mandatory insurance, it was very smoothly. Every ship owner got a blue card as a confirmation that the ship is entered with the P&I clubs. And now what is lacking? It's lacking the direct action. What we are saying, all we are saying is that it is very easy to establish the right to sue the insurer because you arrest the ship anywhere in the world, or you threaten to arrest the ship, and the club would issue a letter of undertaking. And what we say as well, it is that we would copy the terms and conditions of the letter of indemnity. So we are saying you can sue me only if you already obtained final non-appealable judgment against the ship owner. And if you do, and the ship owner doesn't pay, we shall pay. It works. It's day in, day out business. It's nothing dramatic that we are proposing, which is not already in place. And so we don't have to worry anymore about insolvent or not amiable carrier, because the money would be provided by the insurer. So this is as well a very important point. It's about jurisdiction and arbitration. The tide has changed. The common rules are not enough anymore, and I will explain you why. See, this is a typical case which happens in the many ports of the world. You have here 30,000 metric tons of cargo was measured ashore and loaded on board the ship. So you measure again by the ship measures the cargo, and there is again 30,000 metric tons. What you do then? You seal all hatch covers by independent surveyors, and the ship arrives in the port of discharge, again, you measure the cargo by ship draft, and again, you have 30,000 metric tons. Then the cargo is discharged, and you get FP hold certificate, which says all the cargo has been removed. We have looked at the holds, and holds are empty. No cargo is there. And then the cargo is measured again on shore, on truck or rail carriages scale, and they find that it is 29,500 metric tons, which means 500 metric tons have disappeared. Where? That is what we call a paper loss. It's not a real loss. It's just and then what happens? Then the receivers sue the ship owner in the local court, and the ship owner says, "Oh, I have a lot of evidences. Look, here, everything is where we were measuring before is 30,000 metric tons, and we have empty hold certificate. So really, we are not responsible for the loss of 500 metric tons." The court said, "No, I would rely on the shore figures, and you get the judgment against the ship owner." So that disappeared the cargo. So what we are saying is that we need a lex mercatoria, which means that forum should be designated and by the jurisdiction and arbitration clauses. Parties should be free to decide where to litigate or arbitrate. And in all contracts all over the world, it's usually London or New York. They are impartial, they have good quality service there, and you know that you will get a proper judgment. Only in the line of trade, where the single contracts are, then there should be an alternative to the agreed forum, and that could be a place of delivery or some other venue. This is a protection of the customers, where you have just a customer who has not negotiating power, so you protect him. But otherwise, there is no point of protecting other shippers who would like to avoid London arbitration or London jurisdiction and to go for Morocco or any other country of discharge. So what we need that new lex mercatoria. This is carriage of goods rules, so the basis of liability. But the parties should be free to choose the general contract law, which means the governing law of the contract, which would deal with other important questions like mitigation of damage, good faith, and other things which are not covered by the carriage of goods rules. And then in the end, what you need, good quality tribunals, which would evaluate the evidence by international standards and give their verdict in a speedy and fair manner. And another proposal is maybe to have an arbitration center by UNCITRAL. And all these ideas are put in this little book, which we are going now to present to CMI in Amsterdam. And hopefully that creativity would work and people would say, maybe that is a good idea to try to find out what the industry thinks about these new proposals. Another approach which is competing with this one is sunk cost approach. So we already have Rotterdam rules for decades. Nobody wants to implement them, but it is a pity now to throw them away. We should lobby European Union to accept these rules, and maybe then America and China, as the largest trading nations in the world, would accept it eventually. In my opinion, it is not good to try to impose the rules from above. It is rather that the industry says, we need a lex mercatoria, we want the amendments, and eventually, whether or not we would succeed. But at the moment, there are lots of skepticism around, and the biggest problem is the direct action against the insurer. And what I present to you today, this of course open to discussion, is whether or not you think that the direct action as we propose them would make any dramatic change in the business of the P&I clubs. So the last thing which I would like to say is that the greatest pleasure in life is doing what people say you cannot do. So we'll see what will happen. So this is the end of the first part. So we lost 30 minutes. Okay, shall we make a short break and then we put the other presentation? Yes. Any questions?
Question from Professor Kragić.
Sounds too long. It's too complicated. I wrote one thing of Article 47.2 for partitions that understand that they need close to runtime called monster article. It's very, very complicated. For us professors who bring them out, it's very nice because we can write papers. Practitioners so that was one problem. And then the problem is that it deviated from the target use, something which was well conventional. It was much better approach to modernize make it short and just add some innovations. So that was strategic problem. Now that's what you propose about direct claim against PMI clubs. What would be the reaction of UK? UK is generally not keen to accept Rotterdam rules. It's a direct claim because you don't have most of PMI clubs in the UK. And they complain when that was one of the objections CLC convention. Something which is already not very likely that British ratify becomes less likely. So even if China and the United States ratify this convention, if UK stays outside the because you know that most of these claims actually end up in English courts. So it will be something which rules are supposed to restore uniformity, but what would be actual effect is further fragmentation of applications. So it's, this is something which you propose as for lex mercatoria.
Well,
so it goes beyond, besides separate from Rottenham rules.
No, it's part of it.
It's part of it.
And the reason we are proposing that is my experience. I was sitting in the UK board for more than a decade, and I had seen all the changes which were made in the meantime. There are a lot of discussions about any of those international rules, the OPA and all the others. And you know how they finish everything every time. They say, if we do not do that, somebody else will take our business. And they were just expanding all the time. And now you have already money for insurance, it's for the crew, for the salaries, and many other things which even for OPA, as I said before, at the time we discussed it in the board, and nobody wanted to accept it because we were afraid that what would be the limit of liability for the ship for the insurer. Nobody knew what the American court would say in the end. And they said it's not insurable. And then ship owners pressed on that, and so they found a way. They made a trust in Bermuda, and the trust was completely separated from the club. And SICO was incorporated there, and I was in the board of director of SICO for some time. So I know how that works and how they find a way to accommodate American requests. No doubt they would accommodate what we are proposing. It's only up to the industry, basically, for the shippers and the others to say, we like that, we want to have that, and as they have started issuing blue cards for European directive, they would be issuing it. They issue it for wreck removal, they issue it for CLC, they issue it for everything, and they will be issuing that for this as well. So this is, I think this is just that means that this is maybe the best way to explain. When I discussed that with European dive clubs, and they said, well, look, because they have published my article about that earlier, they said, we will publish it, but not on our side. You put in some other side, and then we will just direct. There is somebody, there is just an opinion over there, but it's not made by us or through us. So they don't want to be first among the clubs to start the discussion or initiative of the mandatory insurance. But if somebody else presses them, they will accommodate, no doubt about it.
Would you mention free in the context of Mr. Petar, that would be not enough for English laws for English laws. They don't have the will say they don't know what does it mean because they have something different which replaces the communication or respond.
No problem. There is already the reason why everybody everybody wants to introduce English law as a government law. So obviously everybody, a lot of industry trusts the English courts. So that would be in the future as well. So what we are saying, we should have international laws which would govern the basis of liability, but let the parties decide which governing law they want to apply for the other issues, and let them choose the court to which they trust. So if we would be, say, if you would be constructing or touching the car to the ship to Italian ship owner, and you are getting the cargo from India to, I don't know, Middle East, then you still agree English law and English jurisdiction. They have nothing to do with that. That's a good service. And in the Middle Ages, the fairs and these local markets, the merchants among themselves would choose the arbitrators. So we have a dispute. Please, would you resolve it? Because why? Because I would like next year to come again to the fair, and if the dispute is not resolved, and if I don't want to pay, they would not accept me there. So they have interest for a fair and quick resolution of the dispute. And I don't see why, if every all the industry is agreeing on English law and jurisdiction, or New York law, or in Singapore now, let them find a fair substitutional and law to resolve this.
Your presentation. Yeah.
Well, everybody will be descending.
If I'm on the right track, the idea to have PLI clubs cover for direct action is very, I would say, very human way of thinking. Because we always speak first about the claimants, beyond people, small pools, crew people, their families, whatever, etc., etc. And I think it would be, however, quite pessimistic that they would ever agree to the path that they could be taken. And I agree with what you say that you arrest the ship and they ship and these all the difference. But as you know from your own experience, there is no just automatism in giving guarantees. It depends on the relationship between the client and the member, whether the ship is still insured with them or not.
Of course, they want
to. So if they are not prepared to issue the guarantee for the reasons because the ship owner is in breach of contract with the United, would it be fair to have direct action still against the United?
It's the same with the Kragić convention, with the CLC convention, it's the same position. They issue and they have their own risk whether or not
they have to see whether the conditions for issuing guarantee are all there.
Here, they will take direct actions only if you have a final judgment. That's it. And all other, the same conditions in terms as for all other conventions where you have direct actions would have to be met for CLC, for seafarer, for everything else. So it works in practice. So it's just we have to step over that line and to say, well, we would include it as well. So it is the same situation because under the European directive, cargo claims are insured.
Absolutely. I don't know. I agree with you. It'd be nice to see that. That's skeptical. Industry will take.
It's a fun. You try, you will see. Unless you try, you never know. You know what Kennedy said when they were going to the moon? First time. Yeah. He said, we'll do it not because it's easy, because it's hard. So
okay. One question. What's your opinion about the future of Rotterdam? Because Spain is part of the Rotterdam. What's your opinion? 2024? I'm not agree. I'm not agree with Rotterdam. Expensive, but complicated. I mean, there are many conventions complicated with that. For example, the Convention is very, very complicated and that's 84 registration. So, I mean, just question of study and what's your opinion about it?
The industry doesn't like that because now they have some certainty and the body of rules, especially in the English law, because there are a lot of cases in the English, are already there. So they say, we know what's going on. And if you have now Rotterdam rules with all these complicated solutions, and then you start trying all of them on the, in front of various courts of the world, and they say there is no need for the Rotterdam rules. And my opinion is that the Rotterdam rules, what they do actually, they should, in a way, they're trying to protect ship owners, shippers' interests. What we said there, that there is no carrier with empty pockets. So they say, aha, you can sue everybody else. So if the carrier has, maybe the stevedore has, maybe somebody else has money to pay it for. So it's all about paying the claim in the end. So we said, but this is $3 billion sitting there in the fund. So why you don't go to collect it from the fund, but you are chasing people around the world and try to collect contracting carrier, actual carrier, performing party, maritime performing party, whoever, and then you try to recover. So one of the things that we don't have time to discuss it now is one of the arguments is that direct action and mandatory insurance should be only to protect public interest, like oil pollution and things like that. And if there's no public interest, but if there is no public interest, why are you giving that great opportunity to sue 5, 6, 7, or 10 people there? Obviously, because to ensure that the card claimant at the end would get money. So if you do it by way of allowing them to sue anybody around the ship, so better to go to the fund where the money lies and recovered. So that's the idea. I don't know whether we have time.
Just a short comment to go back on what Zora said. I talked to Petar the other day. With Dr. Story, who made it, you remember, in full review of your future publication, and that was the main opinion that, as you said, you have a poor port or a crew member or his family is deceased, or even passengers, or you want to protect the environment, CLC. You always have some kind of private public interest, where here you have cargo interest, and it's difficult to explain cargo interest to public. So that's maybe one of the obstacles in the. And I agree with Petar. It make things simpler for everyone.
But Igor, yeah, but I have a counter argument as well. It is completely private, isn't it? So why don't you take care about your counterparty? Make sure that the carrier has money, make sure that he has a good reputation. It's a private business. And why we should then provide opportunity to the cargo interest to chase everybody else? Because it's a private thing and sort it out with your counterparty. For example, you remember that there was a case for shipbuilding case when there was the ship was ordered by a shell company, nobody was in. And they said, well, we know who is behind it. But again, you know, why didn't you ask guarantee from the mother company? It's your problem. And you cannot now skip it through and try to ask the court to breach the limitation of liability, to pierce the corporate veil, and to pay for the ship. They said it's private. You should have done it before. So I can say to the cargo owner, ask for guarantee upfront, so they can do it. And then the ship owner would have to find funds to give guarantee upfront, because I don't know, and it's especially for the ship owner, is not such a problem because you can always arrest the ship. And my frustration on the side of the ship owner is that you cannot chase the charterer. Charterer is just a table and account in a bank, little money and some money somewhere else. And who cares about the ship owners? Nobody. So it's a counterparty risk. You have to make sure that the charterer in the end would pay. Maybe you can arrest the cargo if it belongs to the shipper. So it's questionable. I mean, this is what we are talking about: analysis, creativity, open-minded. You can a lot of twists and turns. You can always turn the argument other way around. So I don't know whether you are in the mode at all. Doesn't work again. But anyhow, that would be fun.
Try.
Yeah. So we shall try to go beyond the text and maybe I can, in a nutshell, give you an overview of the problems which we had with the tools. So the talking points would be, I don't know whether we go through all of them. I will start with the Bright Star case and then end with the Bright Star case with the question whether the convention would solve the problem which we had with the Bright case. And in the meantime, we might mention some of the other points of interest. You can choose any one of them if you like, or we can go through some of them. So what's the problem was? It's the Bright Star case. The ship trading Fabrizia was arrested in Jamaica. And there were a lot of claims against the ship for unpaid bunker, wages, and so on. And among others, there was a mortgage, was a debt secured by a registered mortgage. And the mortgage was not paid. And $3 million were reserved by the court in Jamaica. And the mortgage was governed by the flag of Malta, so by the law of Malta. And a Greek ship owner boarded the ship and registered the ship under the Liberian flag, renamed it the Bright Star, and the ship ended up in Malta for bunkering. And the mortgagee arrested the ship. The arrest was lifted against security, and the case ended up before the courts in Malta. What the court said, that it is not sufficient to the court in Jamaica to have considered the Maltese registered mortgage solely as a proof of the mortgagee's credit and to reserve the sum of $3 million for the mortgagee to submit the claim. The Jamaica court had to apply Maltese law relatively to the mortgage in its entirety, and thereby the mortgagee should have been first credited to have been paid from the proceeds of the sale, and Malta cannot acknowledge the sale in Jamaica as having been made as free as an incumbent. So it was the mortgage was for $3 million, but the debt was a little lower. So it is Lex Bandi was Malta, and you have this government agency, Transport Malta, and this is a big business in Malta, registration of the ships. So what they did, they are advertising, saying the Maltese mortgagees offer adequate protection to the ship financiers. They enjoy a high priority in ranking of claims against the Maltese ship, and mortgagees constitute executive titles and may be enforced immediately without the need to institute a lengthy court proceedings. How can I go? So what the point is that under Maltese mortgage is executive title. So what Jamaica court did, they said, no, this is the money, and you have to sue it again in Jamaica, obtain a judgment, and execute the judgment against the deposit. And the court in Malta said, no, it's executive title. It is, you should have applied Maltese mortgage in its entirety, which means you should have paid against the mortgage. So that was quite publicized in the media, and Fenech says that that's a chaotic situation leading to huge uncertainty in international trade, which we need to avoid. How to solve it? By the convention, and this is the schedule of the convention. Everything started in Dubrovnik, where it was suggested that such a convention should be considered and later maybe drafted. So how the convention works? So you have a state of sale, and you have a willing buyer. So the judgment passed, and the willing buyer becomes the purchaser. He buys the ship. But he needs to register or lift the rest of the ship in another state, which is the state of recognition. So the judgment, the judgment has to be recognized in the state of recognition, and only then you can enforce it for various purposes. So what I said, instead of a recognition of the judgment, the state of sale would issue a certificate, and that certificate would have effect in all other member states, which mean under that certificate, you can be registered or lift the rest of the ship. So that would might work it much easier. So instead of having judicial sale, only the certificate would be issued, so the judgment does not need to be recognized and enforced. The certificate would do the job. So judicial sale should have the effect in every other state. And so now this is interesting thing. The word recognition has been deleted everywhere in the document and replaced by the word effects. Why is that? Because European countries ask for that replacement, and this is due to a dispute between EU and member states who has mandate to negotiate. And so regulation, the European Union has a regulation on recognition and enforcement of the judgments. And the argument of the member state was that certificate shall be issued after enforcement has been already completed. So what the argument says is it's a judgment, it's enforcement because the money, the ship is sold and the money is paid. So we are not dealing with enforcement, we are just giving effects to the sale. The Croatian delegation and we together did it. We said that regulation does not cover jurisdiction in rem against a movable object. You cannot find it. And when it comes to the proceedings in rem, it says actions in rem are available only against immovable property. And ship is immovable property, so it does not. So the regulations talk about actions relating to liability from the use of operation of the ship with regard to the claims of limitation of such liability. Only limitation of liability is dealt with, nothing else. And in the end, we have special jurisdiction, which is the place of arrest, and it talks about salvage of a cargo of freight. So this is concerning the payment of remuneration and claim in respect of salvage of a cargo of freight. So no ship is mentioned. So we said it is a lacuna in law, and the lex specialis should then be applied. But European Union still wanted to negotiate, and here they asked the European Commission for the mandate to negotiate. And the answer was a mandate to negotiate has become irrelevant. Such a decision would be contrary to Article that, which contemplates the granting of a mandate to negotiate only during negotiation. The instrument was already negotiated, so you have nothing to do anymore. But they were persistent. And in the end, they managed to include this clause, which is saying this convention shall not prevail over conflicting rules of a regional economic integration organization, which is EU, but with respect to the transmission of notice and concerns jurisdiction rules against the problem which I have just indicated would come again, because we would then argue that the regulations do not cover arrest of ships. So it hasn't been resolved, but we shall see. So what are conditions attached to issuance of the certificate of judicial sale? So there must be a judicial sale. It should confer clean title. It should be conducted in accordance with the requirements of the law and the requirements of this convention. So what is the judicial sale? Judicial sale means the sale of a ship by the court, for which the proceeds of sale are made available to the creditors. Before, in revision number 2, we have a scope of application which says that the judicial sale of a ship following a seizure, confiscation of by a ship of the ship by tax, custom, and other law enforcement authorities, that convention would not apply to such arrest. But it was taken out later on. So we propose then that the judicial sale would mean any sale of a ship for the purpose of imposing recovery of private and commercial claims only, for which proceeds are made available to the creditors. The reasons we have proposed this is that the ranking then would be governed by private maritime law. So there is International Convention of Maritime Liens, and which we discussed before, and arrest conventions, they do not recognize claims for tax, custom, and other purposes. So what does it mean that the sale, that the proceeds should be available to the creditors? The taxman is a creditor as well. So if all the money goes to the taxman, that's judicial sale, and the certificate would be issued. Should any money trickle down to the private creditors? And what does it mean, whether cash should be paid or whether just security for the claim in the end would be provided? We don't know. So about notification, draft prescribes notification notifying parties, minimum contact, conditions for issuance of certificate, law and jurisdiction. Now, and this is interesting, we come to this point now. The notice shall be published by press announcement and transmitted to the repository for publication. So the question is, what if the notice is not transmitted to the repository or other breaches have occurred? So there must be some sanctions. For example, in football, if you foul your opponent, you get a red card or penalty kick. And here there is no sanction, and everything depends on for the court in the state of sale. You go there, and you didn't publish it on the public on the internet, but you don't know what in the end the outcome would be. Only what you can do is in the state of recognition, and you say, for example, if the notification was not published to the repository, that is against, manifestly against our public policy. And then you say, I would not accept that certificate and effects of the judicial sale. So what's the role of the repository? IMO accepted to publish notifications for the judicial sale of ships on its website. So an icon would be added, judicial sale of ships, and you will be able to find there whether any ship is arrested or is put on sale. This is very important. IMO is running the repository, but the content is managed by the state. So you put the notice on it. So what we propose then is a judicial sale should not have effect if a court, the other state party determines that a notice or certificate has not been made available to the public according to Article 11, which means through the repository. and that was rejected. But the idea was that you have classical notification, which is governed by the law of the state of sale and would be determined by the state of sale courts. But on the other hand, the state of recognition would control publications on the email platform, because it's very easy. The judge could find out whether the notice was published. If the notice was not published, then they say we would not recognize the judicial sale. If it was published, then it's fine. So my argument then was that, okay, we shall leave everything to the state of the sale, but that last thing, which is the digital notification, which is so easy to determine whether it happened or not, let us, as a last defense, have to check on that. So what I'm saying, we don't care what happened with the classical notification in the state of sale, but if you have put it on internet, then I have a comfort that creditors should have a chance to find out that the ship is going on sale. But that was not accepted. So what is the consequences of avoidance of the sale? There was a provision, the effect of avoidance of judicial sale shall be determined by applicable law. We said that doesn't make sense. Every law which applies applicable law. So we said by which court, and we proposed the effects of evidence or suspension of judicial sale shall be determined by a court in the state of judicial sale or any other state party, provided such court, according to the Lex Fori, has jurisdiction. CMI did not like it, so they wanted still to go back to the state of judicial sale and said the effects of avoidance shall be determined by applicable law in the state of judicial sale. So eventually, it was decided that this convention shall not govern the effects under applicable law, and we do not need applicable law anymore, of a decision by a court exercising jurisdiction under paragraph 11. What does it mean? In a state of sale, the sale is avoided, but what the effects would be, it is not a matter of the convention anymore. Now, any other state would have a right to decide on it. So whether you would register the ship or what happens thereafter, after the sale was avoided, so it's left to the courts of national states, and the convention would not rule on that. So in the end, the bright star, the question is, what would happen if instead of the judgment from Jamaica, we got the certificate of judicial sale? The question is whether the court in Malta would say that the effect would be manifestly contrary to the public policy because the Jamaica Code did not recognize the mortgage governed by the Maltese law, like Bandi. Proceeds of the sale cannot be made available to the creditor, and the principle of international reciprocity and comity has been breached. So still, after the convention has been passed, the question is whether or not the court in Malta would decide that the action of the courts in Jamaica is manifestly contrary to the public law of Malta. So I don't know whether we solve the problem with the convention which just has been passed. Thank you.